Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello, and welcome to Arbitration World. My name is Declan Gallivan, and I'm a Senior Associate at K&L Gates. I'm, of course, biased, but I have to say, I think this mini-series is excellent. Why? Two reasons. First, the topic. We'll be discussing how to efficiently and effectively manage arbitration proceedings. So, for example, we'll be looking at what can disrupt the smooth flow of an arbitration, and how can we tackle the causes of that disruption. This topic has broad appeal and is of real practical importance to clients, legal counsel in arbitrations, and arbitrators. The second, and I think stronger reason why this mini-series is excellent, are my guests. I'm joined by two leading arbitrators, Lucy Greenwood and Klaus Reichert. Now, before I ask my guests to introduce themselves, I'm required to mention the following. This podcast series is limited in scope as appropriate for a general audience and applicable time constraints. The information in this podcast series is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. And all speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone, and do not necessarily reflect the opinions or views of K&L Gates LLP or any other entity or individual. Right, Klaus, over to you to introduce yourself, please.
Thank you, Declan. I'm a barrister based at Brickcourt Chambers in London. I started my working life as a barrister in Dublin in 1992 and have drifted into arbitration over a number of years, and I now solely sit as an arbitrator. And I've been fortunate to sit in cases in various parts of the world and under various systems, and I'm delighted to be here, and thank you for inviting me.
Thank you, Klaus. Lucy?
Well, hello, Declan, and good morning. I'm absolutely delighted to be on this podcast with you today. Like Klaus, I've been involved in arbitration now since the 1990s, but unlike Klaus, I started off life as a solicitor practicing with two major international law firms, but specializing in arbitration really from the get-go. And since 2017 now, I've been practicing full-time as an independent international arbitrator, specializing in energy disputes.
Excellent. Thank you both so much for joining us. Let's get stuck in. Klaus, when you're sitting as an arbitrator, what are the most common things that you've seen go wrong to disrupt the arbitration process?
I think the first problem that arises, and this permeates through the entire process of a case, is that if parties don't get off on the right foot, or people don't understand what it is that they're doing, or have a common, clear understanding of what they're doing throughout the case, that is the greatest risk for something going wrong later on. Because, as you know, this international arbitration world is now no longer simply a small group of lawyers in a couple of key cities. This is a global practice with practitioners everywhere. And people have trained and have had experience in multiple countries. So what is now happening is that there is multiple participants from all over the world, multiple parties involved in arbitration. And with that multiplicity of parties and multiplicity of legal cultures, multiplicity of business cultures, it can very often be the case that the words on the page may look the same, but they are very much understood by people in different ways. And this goes back to things like concepts of what is a proof, what is submission, what is cross-examination, if really known to a party. And these are all concepts which are rooted in people's original training, because, of course, most, if not all, the people that I have seen as counsel in cases are themselves practicing lawyers from somewhere. So they've had their training somewhere, they have their background somewhere. There's very, very few people indeed who emerge chrysalis-like into the international arena and have not had a fundamental training in some legal system. And the rigors of that legal system, whether it's proof, evidence, or whatever, or how the law is applied to facts and how facts are seen and how they're proven. So I think if, this is a very long way around back to where I started, unless there is a common understanding of what it is we're going to do in an arbitration right from the beginning, and it may be a bit pedantic and didactic to go through this, but I have lost count of the number of times that this has been a valuable exercise in order that everybody understands what we're doing on each stage and why we're doing it. And people then go away knowing what they have to do, because when the tribunal concludes its first procedural meeting with the parties, and, we have the old thing of getting the clients involved and all of that is fine. That's all Arbitration 101 stuff. But making sure that everybody leaves that procedural meeting with a clear understanding that they know what they have to do and the other side knows what they have to do. That, I think, reduces the risk of something going wrong.
Thank you, Klaus. Really interesting to remember and reflect on the fact that a concept in one jurisdiction can have a very different meaning in another jurisdiction. Lucy, what's your reaction to Klaus' comment about ensuring that at the end of the first procedural meeting, the parties really understand what they're doing at each stage of the process and why?
I completely agree with Klaus's point about trying our utmost to get the parties off on the right foot, as he said. And this is a far more challenging and subtle process than I think people necessarily appreciate. I mean, at the end of the preliminary hearing, which kicks off the process, which Klaus touched upon, you really want to be in a position where you have achieved buy-in to the process by counsel and parties, confidence in the tribunal, and somehow being able to set expectations for conduct and behaviour throughout the arbitration going forward. They're very easy to say, they're very difficult to achieve. And as Klaus mentioned, Arbitration 101, we have all the standard things you would do at a preliminary hearing, but an experienced tribunal will go that little bit further. Try to make sure that counsel are engaged, but more importantly, I would say clients that are attending the preliminary hearing, and again, Klaus mentioned this, but that they feel that they have been properly listened to by the tribunal. Klaus also touched upon slightly cultural differences, and I see that quite a lot. I do a lot of my work is US facing. I spent 10 years living and working in the US, and as a result, I still have a lot of US cases. But you may have a situation where you have English lawyers on one side and US lawyers on the other, and as we know, the legal cultures are very different. So again, you're trying your best as a tribunal to set sort of common expectations of how the arbitration is going to proceed going forward.
I'd like to pick up Lucy's point about the divergence between English legal practice and US legal practice, because again, that's something I see a great deal of myself. And it is actually, there's the old phrase about being two nations divided by a common language. And that actually is quite an important thing to remember, because the trial for most US, in fact, if not all US counsel, the trial is incredibly important. That's because of the various pre-trial measures in litigation that parties engage in, whether it's depositions, discovery, and so on and so forth. And so the actual oral hearing, the trial, becomes terribly important. And then I've had this in a number of US cases where the counsel says at the end, and we'd like to comport the relief sought based on the evidence. Now, this would be quite alien to practice in London, or practice particularly in France and Switzerland and Germany and so on and so forth, where the prayers for relief are very important to be set from the outset, because that frames the tribunal's powers. What is it that you're being asked to do? And I think this is an area where that discussion is particularly important. When you have a counsel, let's say in the US, and counsel maybe in England or counsel in Europe on either side, that dialogue is tremendously important from the outset, so that there isn't, let's say, people may feel that they understand and have bought into a process from the beginning. But as I said before, the words on the page may mean different things to different people. And the message sent by the PO1 and even the discussion in the CMC may not be the message actually received. I'm not saying that lawyers universally are socially inept when it comes to receiving messages, but we are so incredibly focused on words and our view of words that is sometimes the point where mishaps can occur. So I think from your listeners' point of view, particularly listeners in the US and listeners in England, when you're involved in a transatlantic dispute, I think this type of dialogue is truly essential so that the process does not become asymmetrical.
Thank you, Klaus. Lucy, Klaus has talked there about how essential early proper dialogue is to commonality. How do you as an arbitrator try to ensure things go smoothly? So what are, for example, some practical steps you take in the first procedural meeting?
It's a great question. And as I said, the whole issues around the preliminary hearing are much more nuanced than I think people appreciate. I think it is very important to have one. Occasionally you'll have cases where parties will agree PO1 and say, let's dispense with the preliminary hearing. And obviously, there's some cost attributed to the preliminary hearing, although, they should always be, in my view, remote hearings. There's not really a need these days for them to be in person anymore. But I tend to like to have them, even if there's only limited elements to discuss. I like to give parties an opportunity to set out their positions very, very briefly. I'll give them 5 minutes to give me a helicopter view of the issue, because again, I think it helps for them to feel that they've been heard. In terms of making sure the process runs smoothly, that's very difficult to do. As I say, it comes down to ensuring there is buy-in to the process, and that's why it's important to have, if possible, clients on the line as well. It's important that the counsel have confidence in the tribunal. They have been listened to with regards to the timetable, but that the ultimate timetable is in the remit of the tribunal. Because again, it can be quite difficult if parties agree an incredibly lengthy timetable, or conversely an incredibly truncated timetable. There needs to be a dialogue there and an understanding that the tribunal's role at this early stage is to do its best to set an efficient timetable that is going to be adhered to. So there's an awful lot going on in that preliminary hearing that people might really not be appreciating.
Thank you, Lucy. Klaus, any further thoughts on this topic?
Yes. In terms of keeping the show on the road, or the so on and so forth throughout the process, something that I've seen and personally was slightly uncomfortable with, but have grown to like it, is that at the CMC, you tell parties, we're going to be a tribunal that's going to keep an eye on progress. And whether you like it or not, we're going to have periodic case review conferences with you. Now, this is not an excuse for everybody on the team to turn up. It will be lead counsel on each side, just to keep an eye on things. And we will ask you, how's progress? This is not an occasion to start advocacy, because that will fall flat. But we simply want to know how things are going and making sure that things are moving along. And what it does is you'll pick a certain number of dates throughout the briefing calendar to have such meetings by Zoom or Teams. And I've found that actually now to preempt problems before they even arise. And that has been quite useful. Now, there is an expense associated with that, because it does involve, particularly when it comes to hourly rate tribunals, whether LCIA or PCA or ICSID, there is actually an expense associated with that. And there's also the greater expense is likely to be the party representatives on each side. But it does align with the old phrase, a stitch in time saves nine. And it's something that I've certainly am warming to now the more I see it.
Thanks. Lucy, is that something that you've seen built into the process? Over to you.
It is, absolutely, Declan. I had a similar initial reaction to Klaus. The idea that you're putting in these little punctuation marks throughout the arbitration where you're going to gather and just check in. It's horses for courses. So I've had them in certain cases. I've imposed them in certain cases. In others, you think, well, that's probably not necessary. I think you can get a sense of how much checking in is going to be required quite early on, but certainly it's a useful tool to have in your arsenal, as it were, in order to keep the show on the road. And these type of check-ins, they can literally last 10 or 15 minutes and be done as Klaus says, quickly over Teams. But just to have are we all on track? Is everything organized? Is the hearing venue booked? Those kind of simple things that just need to keep the parties going in the right direction. So I would say I wouldn't necessarily be using that approach in every case, but certainly I do consider it in most cases and use it in some.
Thank you both. Really clear message there that building in regular, brief and importantly well-managed check-ins can bring real value. That's it for episode 1. Thank you so much for tuning in. Thank you, of course, to Lucy and to Klaus. In episode 2, we focus on document production and witness statements. Thank you again.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.